Good afternoon. I'm Sarge Carlton. I'm here in Harrisburg, Pennsylvania, and welcome to the National RTAP Teleconference. Right now, Pennsylvania Secretary of Transportation Howard Jerusalem has a message for you that he recorded several days ago. We'll hear that now.
On behalf of Governor Robert Casey, I am happy to welcome you to this RTAP National Teleconference. It is our pleasure in Pennsylvania to be your host for the day. The time you spend on this teleconference will be a real investment for you. You will hear from national experts who know your concerns and can answer your questions on a number of important topics and issues facing all of us. We will talk about civil liability and how to cut down the number of lawsuits municipalities and state governments face. You will learn up-to-date strategies for work zone traffic control, as well as planning traffic safety programs. You will also hear some of the latest information on the National Commercial Driver's Licensing Program. I am proud to say that Pennsylvania has taken a leadership role in the country in putting a CDL program in place. You will hear from a number of Pennsylvania experts who will tell you what we have accomplished so far and what we plan to do between now and 1992, when all commercial drivers will have to be relicensed. Take an active role in this teleconference today. It is an outstanding opportunity to share with others in your field what you have learned, as well as learn from your colleagues across the country how they have solved problems we are all facing. We all share the goal of developing and maintaining coordinated, safe, efficient transportation systems. National forums such as this go a long way towards achieving that goal. Thank you once again, and enjoy your day.
Thank you, Secretary Jerusalem. So that we'll all understand better the information and discussions that are going to follow, the Kentucky RTAP Center produced a videotape to give us an overview of the national RTAP program.
We're real busy right now, as usual. The amount of work we do used to really get to me. I was getting farther behind all the time. I'm sure you know what I mean. Then I discovered the Rural Technical Assistance Program. Our county executive gave me the number of the Technology Transfer Center nearest to us. I made the call, it reduced my workload, and has changed my life for the better. It'll do the same for you. Throughout most of the United States, the Rural Technical Assistance Program is a call away. Technology Transfer, or T-Square centers located nationwide, provide an interlocking network of support for people or agencies who are involved with local roads, bridges, and public transportation programs. Along with the Federal Highway Administration, state transportation departments, and selected universities, RTAP's T-Square centers help you work smarter by providing sound advice and information through workshops, printed materials, videotapes, hands-on training, and referrals. Helping you get more for less is what the program's all about.
Sometimes I feel like they expect me to do it all by myself.
The resurfacing costs are just so tremendous.
We just keep working with this mess. Every time we get to the end of it, we have to come back and do it all over again.
I feel like I'm just spinning my wheels.
I just can't keep my roads together.
Can't keep my road together? Can't keep up? Potholes, down equipment, wreck schedules. They should know that there is a better way, that help is available. Working smarter is the name of the game. To get ahead, you need to be able to step back and look at the bigger picture. The trick is to find the real problems that are causing your headaches. Those potholes that local residents endlessly complain about. Is the problem that you're continuously patching them, or is the real problem poor drainage, which is prematurely deteriorating your road surface? And that grader of yours that seems to spend more time in the shop than on the job. That problem could be solved with a regular program of preventive maintenance. Finding the real sources of your problems may require a little more effort up front, but in the long run, it will save you time and money, not to mention a lot of sleepless nights. This is where the RTAP T-Square network can help. For little or no cost, you can be receiving the kind of technical and practical assistance you need to get ahead. The program can help you get more for less. More information, newsletters, technical libraries, industry reports, and training guides. More guidance and assistance on how to work smarter, not harder. workshops, seminars, training sessions, video libraries, and computer programs, and more interaction with others who share similar problems and solutions, trade conferences, telephone helplines, and member directories. RTAP is a partnership involving the Federal Highway Administration, state transportation departments, and selected universities. As a result of this strong association, a diverse collection of experience and knowledge is at your disposal. When you work with the program, you're part of a partnership that stretches from Bangor to Bakersfield. Listen to what these individuals have to say about their connections to RTAP.
I didn't know anything about the center, I have to confess. Then I called the center, got some advice, good advice, and until that time I didn't know what we were missing. There was a lot of material there, a lot of ideas there, a lot of expertise there that we had just overlooked.
As a result of a workshop that the center has sponsored dealing with work zone safety and traffic safety, we have begun to do more signing than we used to do for our construction sites. And so we are aware of proper signing and proper barricading, and as a result of this workshop, we've been able to do a better job, I feel, in signing and providing a safer area for the traffic to go through and a safer area for our employees to work in.
It's an avenue for references. I've gone to them to get videotapes on training for, say, grader operation and for bridge and drainage installation. It's a good place to turn to, and they've got the information there. If they don't, they can dig it up for you, and they seem very glad to do it.
We're trying to implement computers into our operation for record keeping and our pavement management program. And evidently there's been some other local governments interested in this very same thing, because now there is a workshop planned later this spring to address that very issue.
Each of these individuals were faced with unique problems, and as you heard, the program has helped them with practical methods of assistance. New equipment information can increase your productivity, reduce your workload, and improve safety. For example, this manhole cover remover was developed by an employee in the Des Moines Public Works Department. The tool replaces the old crowbar method, so it eliminates strained backs and hand injuries. After this ingenious invention was publicized in Iowa's RTAP newsletter, the story was shared with other T-Square centers across the country. This ditcher is another example. After 2 years of use, the county discovered the equipment had more than paid for itself. Clean ditches mean good drainage.
With this machine and weather like this here in March, we're able to go ahead with our ditching just as if it were July and August. This machine has allowed us to cut back the personnel requirements for ditching from approximately 6 to 7 people to 2. We were able to reassign the employees that at one time would have been used for ditching to other type work, and also the only equipment involved is the machine itself plus one pickup, whereas before we were using as many as 6 and 7 pieces of equipment.
RTAP's assistance also comes in the form of transportation highlights. You'll learn about new techniques and technologies that'll help save you money, such as the Oklahoma Bridge and timber bridges. The Oklahoma Bridge involves a technique for replacing short bridges. T-Square Center shared information about a technique developed by Oklahoma State University, which involved pre-casting 25-foot concrete beams right in the county yard.
I learned about the Oklahoma Bridge in my T-Square newsletter. It's a great idea. During the winter months, we keep our maintenance workers busy by having them precast the beams. Then come spring, we're ready to place them. It's easy to do, and it's cheap.
More agencies are looking into the advantages of timber bridges these days, too, thanks to news spread through the RTAP network.
We've used timber on several decks in bridge replacements in our county, and so I checked with the center, asked them if they knew of anybody else in the state that was going that I might get together with and go with to attend this conference. And come to find out I was the only one from our state that was going. So they were very interested in the conference as well, so they offered to sponsor me and to pay my expenses to attend that workshop. And as a result, I was able to go and gain a lot of information about the use of timber in bridge construction, and then was able to come back and write an article concerning this conference and to and they ran it in their newsletter so that it was shared throughout the state with all those that may be interested in using timber in their bridge construction.
I have gone from the wooden bridge floor decking to metal decking and have not been at all satisfied. I've had problems, and I've relayed that to other engineers through the technology program. Dwayne Campbell, meet with him a whole lot, and his county, he's undergoing the timber decking, and I'm thinking about going back to it. It seems like an old method, but it's proved more satisfactory to me than the newer methods.
Information gained through other RTAP centers can help you improve all aspects of your operation. The New Mexico Center's preventive maintenance program, for instance, has been put into practice by hundreds of local agencies across the country. The program stresses the importance of preventive maintenance checks and teaches you how to identify minor problems before they become major ones. In cooperation with RTAP, New Mexico has shared its program with T-Square centers nationwide so others could benefit from reduced downtime and expensive equipment repairs. T-Square centers offer classes, seminars, demonstrations, technical publications, and on-site problem-solving sessions to help you improve your efficiency as well. Instruction you probably could not afford to obtain if you had to arrange it on your own. Developed and coordinated by your T-Square Center, the information presented is done so with an emphasis on needs specific to your region. The benefits of working with the program are numerous. Topping the list is the organized, step-by-step approach to problem solving. Furthermore, RTAP is convenient. T-Square centers are easy to contact. Assistance is available year-round with just a phone call. The RTAP T-Square Network. Get with the program.
It's a nice overview of the national RTAP program, what it can do for you. I'm going to switch gears now. Fred O'Brien is at Auburn University in Alabama. He and his panel will be discussing tort liability with us. After we say hello to Fred right now and the panel of experts and hear what they have to say, they're going to be available to answer your questions. Fred, are you ready for us?
Thank you, Sarge. We're standing by here in the studios in the College of Engineering at Auburn University, and we're very proud to go up on the very first time in our newly established uplink here. We have our experts in the studio, Dan Turner and Shelley Pivnick, and we await your questions. Thank you.
Okay, I heard you here, so evidently the uplink is working. Congratulations to you. As I said before, you participants are going to have several opportunities to ask questions as we continue this afternoon. When you see the phone number appear on your screen, that means that we can begin receiving calls. Please place the call by using the telephone at your downlink site. Now, this isn't an 800 number, so if necessary, call us collect. When the operator answers, please state your name, where you're calling from, and your question. Please be brief, and to whom you want your question directed. Then stay on the line when you're placed on hold. As soon as you hear the beep on the line, identify yourself and ask your question. You're on the air at that point. Please limit your question to 2 parts so that we can get as many of you on the air and involved as possible. The calls you make during and after the Alabama presentation will be answered live from Auburn University. Now we'll begin the discussion on tort liability with a taped presentation produced again at Auburn University.
Welcome to Auburn University and the Alabama Technology Transfer Program. We are very pleased to participate in this Rural Technical Assistance National Telecast. Before we get into our technical presentation from Alabama, I would like to go to the state capitol and have a comment from the governor of Alabama, the Honorable Guy Hunt. Governor Hunt, as you know, this is a joint effort between the federal and state governments and universities throughout the nation. Please comment on the importance of this partnership here in Alabama.
I'm very happy to, Fred. My administration is pleased to continue to endorse this effort to provide technical assistance to the state and local transportation systems in our state. Like other states in the nation, our needs in providing adequate, comfortable, and safe road transportation systems are enormous. Our dependence on these systems to meet the population and economic growth in our state has never been higher. In order to build and maintain the desired modern and safe systems, we need all the assistance we can get. This partnership has proven in the past to be an excellent mechanism to provide our state and local officials with needed educational assistance. Technology developed by the research efforts of the Federal Highway Administration, the State Transportation Research Facilities, and the distribution of this information by our universities are the essential ingredients that make this partnership unique. My administration will continue to endorse this program, and we pledge our continued support in this effort.
Thank you, Governor Hunt. The State of Alabama Highway Department is the state agency that's responsible for this program here in Alabama. The Highway Department has a Bureau of Secondary Roads, and I would like to have the Highway Director, Mr. Royce King, comment on this responsibility. Royce, would you care to make a comment on how this program assists the Bureau in doing their task to assist our local transportation needs?
As Governor Hunt has said, this program provides excellent assistance in our mandated responsibility to serve our state secondary road system and our county and city government needs. The exceptional growth in vehicle traffic, coupled with the impact of traffic exiting the interstate network onto these systems, oftentimes is overbearing. This overextends our resources, both in personnel and in material support. This program provides educational assistance to our personnel, which, at present, is being seriously depleted by our veteran staff reaching retirement status. Young technical personnel being hired to fill these positions are in dire need for immediate training in the state-of-the-art technology in road building and maintenance. Likewise, the county and city governments look into the state agency for assistance in similar needs. We are continually hard-pressed to provide this requested help, and this nationally successful technology transfer program provides a most welcomed aid in accomplishing this task. The State of Alabama Highway Department enthusiastically supports this program and looks forward to future participation and continued assistance. We're sincerely grateful for the opportunity to be a part of this national program.
Thank you, Royce, for those comments. Auburn University is a land-grant university with responsibility in instruction, research, and extension. This program is a function in our extension element. It's my pleasure to present to you the president of Auburn University, Dr. James E. Martin. Dr. Martin, would you please comment on Auburn's role as it pertains to our extension element and how this program has provided us the mechanism to do our responsibility there?
Fred, as the 1862 land-grant university in Alabama, Auburn University has the statute responsibility for certain programs in resident instruction, in research, and in public service. And we're delighted that we are able to participate in this partnership of technology transfer to the people of the state, the region, and indeed the nation.
Thank you, Dr. Martin. Tort liability, a major subject of interest in the transportation industry in the United States today. Today we have in the studio Dr. Sheldon Pivnick, who is Chief of the Traffic Signals and Sign Division of the Dade County Public Works Department in Miami, Florida. Dr. Pivnick is an attorney and author of many articles, including the chapter on tort liability for the National Association of County Engineers Action Guides. We also have Dr. Dan Turner, who is the head of civil engineering at the University of Alabama, and among his credentials includes the chairmanship of the Education Committee for the Transportation Research Board Task Force on Tort Liability. Gentlemen.
Thank you, Fred, for that introduction. Shelley and I want to take just a few moments of your time to give you our perspective of the national tort liability picture. We're going to be discussing the trends that we think are occurring nationwide. Keep in mind that these are strictly our ideas, that we want to try to convey to you what's occurring in case you want to devise a tort liability defense system for your own governmental agency. The outline of what we're going to be talking about fits nicely in 4 pieces. First, I'm going to talk about the status quo, what we see as the national picture right now. Then Shelley will tell you some of the good things you can do, the tools that you can use to try to minimize your own risk. I'll come back and say what I think national organizations are doing, That's the good news. And Shelley will give you the even better news. He'll talk about several states that appear to be doing an excellent job of combating these suits. And Shelley and I share one conviction today. There's good news and bad news on the tort liability front. The good news is that a lot of people are working on it, and we're making great progress. We're making good strides. The bad news is that there is a long way to go. The problem is enormous. That's my job first, is to set the stage for you and to tell you exactly how bad this problem might be. I'd like to look back here at the slide to show you where we wish we had been 25 years ago. If highway agencies had known how bad it was going to be, we could have dodged most of this. As a matter of fact, an assistant secretary of transportation of one of the largest state transportation agencies told me, if we had just known 10 years ago how bad these suits were going to be, we could have saved $100 million. And in doing so, could have had one of the best safety programs money could have purchased. Unfortunately, that just couldn't be done. If we look at our next slide, I'm going to try to share with you what's happened, especially in the last 10 to 12 years, when these suits have mushroomed, when they've taken off. These are questions that everyone is seeking the answer for. If we just knew the types of suits that are going to be occurring tomorrow, we could stop them, or we could at least minimize them. Unfortunately, that's not available. But by drawing upon historical data, we can paint a picture, and a wise man can learn from history. I'm using data that's been supplied by the American Association of State Highway and Transportation Officials. The Administrative Subcommittee on Legal Affairs has performed 5 nationwide surveys starting in 1978. These surveys involve the loss of sovereign immunity and the increase in the number of suits. AASHTO became concerned because the chief legal officers of highway departments across the nation noticed that they were losing an enormous amount of money. These nationwide surveys were conducted strictly to try to find data on how to attack that problem. Let me show you one thing that we need to know a lot about, and that is sovereign immunity. In 1812, that British concept of sovereign immunity, the king is sovereign and can't be sued, came to Massachusetts. And for 150 years, all of the states enjoyed that concept. We could do whatever we wanted because we simply could not be sued. But then the courts began to chip away at that. The legislators got involved, and a landslide occurred in the legal system. Sovereign immunity was lost in almost all states. We can look at this slide that shows what the AASHTO surveys found. Starting in 1978, in AASHTO's first nationwide survey, they found that about 31% of the states still had full sovereign immunity and could not be sued. Slightly more than 50% had totally lost their sovereign immunity at that time. And I'd like for you to note this trend that goes across the screen in decreasing sovereign immunity. That's something you need to be aware of. By 1986, there were only 11% of the states that still enjoyed sovereign immunity. But at the same time sovereign immunity was being lost, states were coming back with tort reform acts or with tort claim acts to put in place a limited amount of immunity. Actually, what they did was to control the way in which the state might be sued, to control the subjects for which suits might be brought, and to offer some protection for the state. If the state and its employees were doing their job correctly and diligently, it offered protection. If the state made errors, were careless, or negligent, it offered the plaintiff a way to recover damages when the state had wronged them. But the biggest thing to remember is that sovereign immunity disappeared, and disappeared in a hurry in the United States, starting in the late 1960s. Today, virtually no states enjoy the full sovereign immunity that once was prevalent. Let's see how bad the suits became once they actually started. This shows the number of claims in the United States. Starting in 1970, there were virtually none. In 1972, the first year for which we have data, you can see right here that there were about 2,000 suits in the United States. The AASHTO survey had very good results along to here about in 1979. And we can see that the trend is one of upward, very rapid change, high growth in the number of suits. Unfortunately, in the latter surveys that AASHTO conducted, there was not a full reporting by the states. About half the states failed to report to the last survey conducted in 1983. And so I've had to estimate what would have occurred. And I took great pains to have a maximum and minimum estimate. And I've discovered that somewhere around 25,000 suits per year is the number that's now being generated in the United States. That's a substantial number of suits. There are worse trends. If we look at what's occurred in the court system at the moment, these are cases that are pending. When these suits are first filed, they don't go to court right away. They may be 2 years or 4 years in the making. So it's very difficult for us to get data on the number of suits. But this chart makes it very apparent what's happened. At the moment, there's somewhere probably around 15,000 pending suits in our court system. That's an enormous backlog. The amount of money, and this is a staggering number, the amount of money is approximately equivalent to the amount of money that's going to be spent on road construction in the United States this year. This slide covers a nice trend of 8 years. It's very obvious what's occurring. They're going straight up. More and more suits are in our court system waiting to be tried, and we don't know the future impact of these suits. I can express it this way. The number of suits that are occurring in the United States involving state highway agencies turns out to be the same as a 20% per year compound interest rate growth. Phenomenal, just phenomenal. Let's look at just a few other things before we quit. This shows the same thing I was discussing before. This is the number of settlements and judgments that are occurring each year. And as you can see, starting really in the late 1970s and the early 1980s, the number jumped through the ceiling. There were not more before then, even though these were being filed, because it takes a long time for these to go through the court system. And to be clear, the states have tried a number of solutions. This is one innovative one that was tried by a southern state. One of the axioms of law is that if you warn the public, a reasonable man can avoid damage. I have proposed another solution. I think we can probably eliminate the entire problem if my friends will just help me adopt this sign for the National Manual on Uniform Traffic Control Devices. If we're going to warn the public, let's do it in a good old southern way. Shelley, you may have a few other ways to take care of the problem. Would you care to comment?
I certainly would, Dan. Thank you. Really, there's no way to keep from being sued, but you certainly can control your risk and limit your liability exposure. One of the major things that government had at its beck and call, as you pointed out, was immunity. The immunity, as you pointed out, again had its beginnings out of the written and unwritten laws, particularly the common laws, which said that if the king could do no wrong, then the king's government can do no wrong. Through various developments in the court system, we came to where we are today, and today we have a dichotomy or a two-pronged approach known as the discretionary function, which is the decision-making function, and the ministerial function, which is the carrying out of orders. The courts today have decided that they are not going to second-guess the elected and appointed officials with respect to the decision-making or planning function. So if there is a true planning or true decision-making, known as the discretionary function, that still retains its immunity. However, when dealing in the non-discretionary function, you're going to find that you're going to face liability and risk exposure just as if you were just an ordinary private citizen. Now, even if you are not protected by sovereign immunity, there are certainly many tools that are still available to protect yourself. They vary from aggressive attorneys to the use of actual legislative approach. Let's look at the attorney's function first. You'll note that the attorneys actually prepare the case, research the case, determine the need for experts, look out and seek for the evidence that is required. And it really basically means that if you have some kind of input to the selection of an attorney, you want to have an attorney that is trained in tort cases and one that has a background in highway transportation cases. Clearly, it is shown that if you have an aggressive attorney, it's going to have an impact, particularly on the elimination of nuisance suits, which make up a large part of the cases that are filed against government agency. Another tool is to try to keep out of courts in the first instance, and that is accomplished with a good preventive maintenance program. Now, if you have a good preventative maintenance program, it better be augmented by a good record-keeping system, because if you do not have that record-keeping system, there is no way to prove, once you go into court, that you have a preventative maintenance program. There are other factors that you should take into account when dealing with a program such as this, and that is to look at accepted standards throughout the industry or throughout government that you should be following, such as in dealing with traffic control signs. There is a need to have those signs examined on an annual basis, both a day examination and a night examination, particularly at night, because many signs that look good during the day do not have the visual impact at night and do not impart the message to the motorist or to the pedestrian that you're trying to warn. There are numerous pieces of equipment, such as retroreflectivity meters, that allow you to accomplish the same thing during the day and make one trip to a location rather than one during the day and one at night. Also, if you're dealing with traffic signals, the courts have consistently said that a good preventative maintenance program requires a semi-annual check of traffic signals. One of the things that you should avoid in dealing with a semi-annual check is sole visual inspections. Many cases have been lost in court because of the failure to use test equipment that has been provided to the technicians who are doing the work. The courts say if there is test equipment, you must use that test equipment. And other things that courts continuously say is that you must avoid that ostrich-like syndrome, and you must go out and conduct an operational review after installation. You must be sure that what you have designed and what you have implemented is functioning in the manner that you have intended to make it do. There are some other suggestions for a good risk management program. Among them is to have an accident record system, observe problem areas and report needed corrective action, be aware of public communications, letters, newspaper items, phone calls. Above all, answer all complaints and document facts and engineering decisions. They are going to be needed when you go into court. Identify high accident locations, improve the warning system, set up a continual program for maintenance and safety improvement, strengthen internal communications, develop long-range programs, and above all, publicize your agency's activities. That little item, publicizing your agency's activity, again has an impact in lawsuits. If the public knows what you are doing, you're going to find a lot of the smaller nuisance suits, which cost a lot of time and a lot of money in defending them, will be eliminated. The use of tools that are available to you certainly can control your risk and limit your liability exposure. Dan is going to get into some functions that professional societies are doing to help you in controlling your risk. Dan?
Yes, Shelley. One of the very positive things is that a lot of national professional and technical organizations have now started preparing training materials and defense materials for governmental units to use in these cases. I'd like to talk about just a few examples of those if I can for a moment. First organization I would like to speak about is the American Association of State Highway and Transportation Officials. I've already mentioned AASHTO and their very vital role in conducting these surveys that allowed us to begin to realize the magnitude of the problem. AASHTO has also been keeping up with information about what the states are doing about the problem now. The latest AASHTO survey showed that 84% of the states responding had put into place a training program to train the employees on the principles of tort liability, the legal terminology, and what to do to minimize the chance of being sued. This is very good news. Another agency that we'd like to be aware of is the American Bar Association, and of course they're going to have information regarding it. I'd point out particularly that the Educational Division has put together training materials on a 2-day course. This is the workbook for a course called Transportation Facility Negligence that's been taught since 1985. Some of the states have also begun to do the same thing. Pennsylvania, for instance, has put out this training course, the Pennsylvania Bar Institute. This course is actually titled Automobiles and Highways, Design Defects and Maintenance Liability. Actually, it could be called How to Sue and Defend Your Local Highway Agency. And so a lot of material is available for attorneys. That's one of the first things that a transportation agency can do, is to train their attorneys in what's going on at the moment. What part of the law is emerging, because the law is dynamic, and especially in the highway field, the emphasis areas change from time to time. Another national organization that you'd like to know about is the Transportation Research Board. The Research Board formed a task force on tort liability about 4 years ago. And this task force is now delivering its national report, which is going to call for the permanent creation within TRB of a committee to study and to maintain a vision of tort liability. TRB also does a number of good things. They are the clearinghouse for publications. I'm holding NCHRP Report 106, which is an excellent place to begin studying tort liability. This is the state-of-the-art report on tort liability. It's being updated, and the follow-up report should be out shortly. TRB also publishes a legal research digest, which is a review of suits occurring nationwide in some target area. They've studied trees beside the road, bridges, defects in surfaces of roadways, or personal liability of employees. A number of those are available, and by all means, get them as a starting place. There are other reports that I could mention. Here's one, a special study by TRB on run-off-the-road accidents and low shoulders. A number of these are available, and they should be obtained and used in starting a program of this type. Let's look at another national organization. Institute of Transportation Engineers has done a number of things. They've been very, very active. They were one of the first organizations to come up with a training course. And here's the workbook for it. This is a 2-day course that's available on demand. This happens to have been written by Mr. Pivnick, among others. And this was a very popular course. It's now been available for about 10 years. ITE has also formed an expert witness council. They're very active and a good place for literature. Another organization we can look at is one that's a late emerger on the field, and that's the National Academy of Forensic Engineers, started in 1982 as an adjunct of the National Society of Professional Engineers. I'm holding here what's going to be the publication for this agency, which is the Accident Reconstruction Journal. The purpose of this organization is to try to set standards, set direction for expert witnesses, controls for them, if you would. This is an organization that you might want to investigate. Now, I also want to point out, if you will notice, that some of my friends told me that my sign, even though I was in love with it, would not solve the problem. And after great study, I've been able to propose that my sign be strengthened with a supplemental plate that's obviously going to be in effect in the Deep South. This sign must be obeyed by everyone who sees the supplemental plate. You hear. Shelley?
Thanks very much, Dan. What I'd like to do is just briefly go into some actions that government agencies have been taking with respect to their own risk minimization program. Through the years, the courts following the federal government's lead in opening up liability exposure have created more liability exposure for both the state and local governments, talking about municipalities, public authorities, counties. After all, the court said we created sovereign immunity, and they did in 1788 in England and then in 1812 in the United States, that we can do away with sovereign immunity if we feel to. Again, state governments became very concerned and reacted in controlling runaway liability by passing the various Tort Claims Acts, which in essence codify what actions the public can take in prosecuting claims and how the states could defend these claims. You have this method to help yourself, and that is by getting together with your state legislators and recommending various remedies and solutions to problems that you can see or can foresee in the future. You can do this by lobbying efforts with direct lobbying of your legislators, or you can establish a series of workshops and seminars for your legislators so they can be aware of the problems that you are facing and also understand what solutions that you can see that they can take by appropriate legislative action. Some of these solutions, for example, Florida has capped the maximum award that any individual can obtain from the state or any of the local governments in the state. $100,000 is the maximum that anyone can legally obtain in a lawsuit against government agencies. Another, and probably the most important one that should be followed by some of the states, is the elimination of joint and several liability. As you may be aware of, you are brought into many of these lawsuits because of the deep pocket doctrine, whereby the government agency has deep pockets. Even if you don't have the funds available, the courts recognize that you have an obligation to pay judgments. And with joint and several liability, what happens is, even though the government agency may only be 1% negligent, and the co-defendant may be 99% negligent, the government agency is not only responsible for its 1%, but is also responsible for the 99% of the co-defendant under joint and several liability. By eliminating joint and several liability, government agencies now become responsible only for their own negligence and not the negligence of the co-defendants. Another example of how legislative action can be used to reduce your risk and minimize your liability exposure. Another of these things is to include immunity as part of the state constitution. If the Constitution has some form of immunity in it, it certainly is not going to be attacked by the courts as being unconstitutional. However, you should understand that the courts still are in the position to interpret it. As you see every day, there are numerous cases that come down from both the federal and state Supreme Courts interpreting the Constitution. But at least with the constitutional requirement, you're going to find that liability will be affected seriously by the immunities that are retained in the state constitution. Some other governments have looked at specific cases and specific causes and have legislated against those causes. One of the ones that really comes to my mind is one of the states has legislated against snow and ice cases. What they have done is they said that government is not going to be responsible for accidents caused by accumulation of snow or ice until a reasonable period of time has passed after the storm has passed, to allow governments to go out there and clear the problem. They are not going to be faced by an attorney that comes into court and says, well, it was snowing, you should have been out there clearing the roads. Clearly a problem that can be eliminated by appropriate legislative action. Another one that comes to mind that should be legislated against, and that is the rule on constructive notice and actual notice. Actual notice of a defect means that you have been actually notified of an existing defect in public property. However, we have another situation where the courts will create notice for you if you have allowed this problem to exist an unreasonable period of time. Therefore, the courts say, knowing that this problem has existed, whether you know about it actually or not, you have a responsibility to go out there and find it. New York City was a leader in the elimination of this constructive notice. They passed what is known as a pothole ordinance, saying that they must receive actual notice of the existence of a pothole before they can be held responsible. By elimination of the constructive notice requirement, you're going to find that a lot of lawsuits that are now being lost can be eliminated through a simple legislative procedure. 25 states concerned about the possible court action eroding their discretionary immunity, the planning function, or the decision-making function, have specifically included within their statute the fact that they will maintain discretionary immunity. The courts in 3 other states, particularly New York, Washington, and Florida, have said that the statute, though specifically not saying that discretionary immunity is being maintained, certainly have implied that discretionary immunity is supposed to exist. We also can't forget personal protection for the employee itself. If your employee knows that they are going to be protected through one form of legislation or not, there certainly is a more confident feeling among the employees, and they are working better. Some states have taken aggressive action. Florida, for example, says that an employee, either elected, appointed, or hired, may not be sued as long as they are functioning within the scope of their employment. they say that the proper party to sue is the government agency alone. Other states, such as Ohio, Massachusetts, and Alabama, indemnify their employees. They say as long as the employee is working within the scope of employment, we will protect the employee to the extent that we will pay the legal fees and pay the legal judgments that are awarded against the employee. They also permit government agencies, by legislative approval, to purchase insurance to indemnify those employees and to indemnify the government agency. Texas has a very aggressive program in dealing with their attorneys and cases. Texas is one of the forefront states in aggressive pursuit of lawsuits to prevent the settlement of unnecessary cases and to send a message to the to the plaintiff's bar that we are going to aggressively defend our agencies. Again, what you find is there is a direct correlation between an aggressive defense and the elimination of nuisance claims that add up in dollars and result in a lot of loss of productive time of the employees of government agencies and high cost in litigation. The final thing that government agencies do, and you're going to find that many of the states, Pennsylvania Department of Transportation is one of them, the Ohio Department of Transportation is another, have taken an aggressive approach and have set up numerous training courses to show their employees what there is in this litigation problem and what programs and what methods are available to establish that, to control your risk and limit your liability. Thus, with your help, governments, both local, state, and municipal, can be made aware of the situation and what action can be taken to limit their liability.
Thank you, Shelley. I'm going to take just a few minutes to summarize the main points that Shelley and I tried to make for you this morning before we begin to answer questions. We had 4 main areas we wished to address. First, we wanted to show you the status quo, to try to tell you how bad the problem is now. And I think we've shown you some pretty large numbers. Secondly, we wanted to tell you that there are some positive actions that you can be taking to minimize your losses in court, the downtime that your employees have to devote to solving legal programs. Thirdly, we want to talk about national organizations who've now had 10 to 15 years to begin to develop materials to address the problem. And lastly, we wanted to show you that states have been busy doing something. This is always an individual state action. The courts in one state may not act quite the way they do in another state. So the individual states have to develop these topics. I'd like to talk about sovereign immunity and impress with you that in 1788, the courts in England created sovereign immunity by saying the king and his government could not be sued. This same principle in the United States came into being in 1812. We incorporated what the British courts had already told us. Unfortunately, for virtually 150 years, we tried to live with that, when it might not have been fair all that time. And because we tried to live with it, we got used to doing some things that we probably should not have been doing in highway agencies. There's an old saying among highway engineers, put your money where the wheels go. That means if you're not putting pavement out there on the road, you're probably wasting money. We've had to change that axiom because we now must recognize that the safety of the motoring public is a major concern. The courts have told us that. They've made it very clear, very plain. I'd like to talk just a minute and remind you of how badly the courts have told us that problem is. We're looking at a time when 20% more suits are filed every year. It's growing now for the last 15 years without a stop at that rate. The AASHTO data is just becoming available for the last year's survey, and it's going to reflect the same things I've been showing you on these trends. We've had an enormous number of suits. We didn't used to have to deal with them. We must learn that those suits are part of doing business. Where all states used to be sovereign, only a handful are now. And dealing with attorneys is the way we've got to live in the future. In 1972, I told you that there were 2,000 suits. I told you in 1987 that there were 25,000 suits. The data that's going to come available from AASHTO is going to show that that's jumped to 29,000 suits within the past year, a 20% increase once again. There's no end to this. It's not going to go away. No national legislation is going to remove it. It's going to be management actions on your part, in your state, with your agency. Pending suits are enormous. The last AASHTO data showed about $9 billion. I have good reason to suspect that that's going to jump to somewhere between $12 and $15 billion in the last year. That's a tremendous number. That's more than the active highway program by the Federal Highway Administration. This is no longer an incidental problem. We're looking at somewhere around 21,000 pending suits currently waiting in the court system. Many of these are the worst suits, the kinds that have hung around forever, that were difficult to address, that we put back and just did not want to face. There are going to be enormous financial losses from them. We can't avoid the fact that litigation is now a major problem for highway agencies. It can't be solved by having our attorneys work harder. It's got to be solved at the grassroots level by all of us doing our jobs as well as we possibly can. Shelley told you some of the things that we can do. Set up a program, work on preventing accidents. In an ideal world, we would simply just eliminate all the traffic accidents and thereby eliminate the suits. We know that can't be done. But I can challenge you to do this. If you go out and eliminate 10% of the most hazardous locations on your roadways, you've eliminated more than 10% of your potential suits, because those locations of the greatest hazard to the motorist are your locations of greatest liability. It's as simple as that. I'll remind you, Shelley made 10 points that he thought composed a good grassroots program to begin to address your own problems. Those were to establish an accident record and surveillance system, to monitor that accident data, to observe your own problem areas, and to report those to a central location, to keep good records of that so you can defend yourself in court, so you can say that I'm taking reasonable actions, I'm doing all I can to defend myself. Be aware of public complaints, and when you do get public complaints, keep records of them, and more importantly, keep records to show that you addressed them. A very effective witness in court is the little old lady who called in because her stop sign was blocked by tree limbs. She can be put on the court witness stand to say, yes, sir, I called in, Your Honor. And they were out there within 2 days and cut all those. A week later, they called back to ask me if they'd been cut, and the drivers could see. I was very pleased that it was such a responsive organization. Remember, it takes positive actions on your part to defend yourself. Identify high accident locations, and by all means, have a program to address them site by site. Find the countermeasures that will reduce the accidents, and then in priority fashion, begin to address them and begin to make those improvements. Establish some sort of warning system. Improve the warning system you now have to find the worst locations on your roadways and to let the motorist know that he's coming to a site where he needs to take some sort of action. Establish continuing maintenance programs, continuing safety improvement programs, keep good records of those, develop long-range programs where you plan enforcement and education programs, and probably above all, take great care to make sure the public is aware that you are a positive organization. The American Bar Association made a very interesting finding. They found that in transportation negligence cases, the state DOT or the local city sued for a pothole, for example, 80% of the jurors decided before the first piece of evidence was offered how they were going to vote. That's startling to me. I know how they were going to vote. If they've ever wanted a traffic signal in front of their home, if they have ever wanted bushes cut or a pipe in their driveway and didn't get service, they're probably going to vote against us. We're working uphill. I'll remind you that good management actions constitute a good risk management plan. And the aggressive manager of a transportation agency, doing all he can to spend his money wisely, appears to be a reasonable man. And the basis of negligence can be summed up very simply. If I were a juror sitting there looking at you on the witness stand as the defendant, I'd ask myself, did that man act reasonably? And if you can show that you took reasonable actions, you've gone a long way toward defending yourself. Very simply stated, the liability problem will not disappear. It's here to stay. You don't know a single industry that doesn't have the best attorneys they can get their hands on to defend themselves. Suing and being sued is a way of business in the United States. We have the world's best legal system. Unfortunately, we in the public domain were lulled to sleep 150 years without being sued. And now then, it's hit us like a load of bricks. We're being sued, we will be sued, and we better learn how to deal with it. Fred.
Thank you very much, Dan. Now we'd like to entertain questions from throughout the nation. If we have one, we will take it now.
This is Ken Jackson with Kansas Department of Transportation in Topeka. And my question deals with preferential icing for bridges. We have in Kansas a statute which gets us out of suits that resulted from ice. The new tactic by plaintiffs' attorneys, though, is to claim that we should have had a warning of the ice. My curiosity directed towards Dr. Spivak is that a national trend trying to evade icing immunity by claiming a negligent signing?
That would probably be the approach to take. If there is a notice of a pre-existing condition and the government has taken no particular action to resolve it, that creates a liability. If there's a notice that ice occurs at a regular time, then probably it would be appropriate to put up a sign to notify the motorist of the possibility of a condition that may or may not exist, but at least to put him on warning. There is a requirement that the government is to notify the public of trap-like or unusual situations that exist all the time, and also to notify them of conditions that may or may not exist if they have noticed that they exist. If you know that a bridge is going to freeze, and it does freeze on regular intervals, then you really want to notify the motorist that he may face a condition that may not be readily apparent to him. Failure to do so would result in a liability claim and open yourself up to an action.
Thank you, Shelley. I understand now we have a call from Georgia.
Yes, I'm Bruce Nicholson with the Georgia Department of Transportation. Even though you've mentioned the fact that if you have continuing programs for correction of some deficiencies, they exist. So if they're out there, are the agencies and the employees liable because they can't keep up with bringing them up to current standards?
I would like to answer that question, Bruce, if I could. First, if the roads did not wear out, there would simply be no need for your job. So we're all caught in the same trap. There are deficiencies across all of our roads. The courts, in trying to decide whether or not you're negligent, apply the standard of care that's available. What standard of care should be used in looking at your roads? If you have a program to regularly look for your own defects, to find them, to program some sort of a treatment for them, that's about all that you can do. The courts generally recognize that we do not have unlimited money and unlimited manpower. So if you're finding your own defects, and most courts have said there's an affirmative duty to look for them, and you're programming them for action, and then getting to them as soon as you can on a regular basis, that's about all you can do. You're going to lose some suits where you didn't get something fixed. But for those that you do lose, you'll lose just a little bit of money. And in court, you'll appear to be a reasonable man doing all that he could to try to cure his problem.
I understand now we have a call from Pennsylvania, and let me suggest that our callers speak up so we can hear you more clearly. Thank you.
My name is Dave Schrock from the Du Bois campus, Penn State. What testing equipment were they talking about that the courts used to identify liability is a one-part question? And where do they obtain this equipment if need be?
I'm not really sure I follow the question. You're talking about equipment that the court uses to arrive at some conclusion? Is that what you're saying?
Yes, sir.
All right. The courts really do not go out and purchase equipment or purchase testing equipment. What the court acts on is what's being told to them by either the plaintiff's attorney or the defendant's attorney. That's augmented with the information that's being provided by expert witnesses. The courts look at that and then they try to arrive at a conclusion. What has happened in several states, one that I'm familiar with, particularly in Arizona, was where there was a situation where a technician went out to repair a traffic signal. What he did was do more of a visual inspection than the use of the test equipment that was provided him. As a result of that, the court ruled that if equipment was provided the technician should have used that equipment and should not have relied solely on a visual inspection. As a result of that, the Attorney General in Arizona sent a memo around to the various divisions in the Department of Transportation, which simply stated, if you provide equipment to your technicians, make sure that they utilize the equipment. The courts do not go out and actually conduct the tests, but they rely on what has become an accepted standard within the industry. If the industry has accepted a standard that it's going to use retroreflective meters or use multi-testers or use loop detection devices that test the condition of loops, and it has become an industry standard, then you're going to be put in the position that you are not following that industry standard, and then you're going to open yourself up to negligence. I hope that answers that question, Dave.
We have another question from Pennsylvania.
Yes, this is Tom Lyons from Williamsport, Pennsylvania. You've mentioned numerous highway deficiencies that contribute to tort liability cases. Is there a particular area, such as potholes or sign deficiencies or guardrail deficiencies, that accounts for most tort cases?
I would say, based on the experience I have, it seems that the improper maintenance of shoulders seem to result in a lot of cases, and also a case that results in a higher type of judgment. Usually what happens with low shoulder cases or improperly maintained shoulders, they result in rollover accidents which have a higher type of injury, possibly rendering someone quadriplegic or paraplegic. As a result of that, you find that the awards tend to be higher. Probably after that, you're going to find your pothole cases and then probably your guardrail cases in that order. But I would say shoulder problem seems to be, at least from my experience, a higher. Dan may be able to answer a little more on that.
Yes, I have looked at the AASHTO data. One of the questions that AASHTO asks the states is to identify your top claims, and there is no consistency nationally. The problems in one state may not be identical to those in another. We can summarize, and indeed, shoulders and work zone traffic control devices, those types of situations are prevalent in suits. But in one particular area, it's more of a matter of the development of the roadway system and topography, whether or not you had hills and curves and streams, and especially the preferences of plaintiff's attorneys. Once an attorney learns the technical details of a low shoulder case, he'll look for other suits like that. He'll publish it in the Trial Lawyer's Journal for his state, and other attorneys will look for those types of suits. And you'll suddenly have a mushrooming of one type of suit. Just across the state line, the most prevalent target may be unprotected bridge abutments. And so I would especially consult my attorneys in the state, your attorney organization, about the types of suits that are going on. Have some sort of a planned program to identify your target areas and make improvements in that area.
Thank you, Dan and Shelley. We have another question now from our sister state of Georgia.
Name is Naif Haddad, Fulton County, Georgia. My question is, you have mentioned that state governments don't have any sovereign immunity as of this date. Does that apply also to local governments such as county or cities? And if it does, to what extent?
Yes, sir. I'll explain just as quickly as I can. Most of the states originally had sovereign immunity by some sort of court action. Very few had it in their constitution. Rarely do local governments have immunity. They were considered to be an extension of the state government and were protected through case rulings. a judge would rule that a city was just the same as an extension of the state and thereby was not sovereign. Most of the cities and counties lost their immunity through additional court cases before the states did. So generally across the nation, cities and counties are less protected than are the state governments.
Many times, Dan, you're going to find that if the state is maintaining an aggressive legislative program to reduce the risk of its agencies, it will write in the local governments as well as the state governments. Florida is an example of that, where the local governments, the cities, the municipalities, the county agencies, the public authorities maintain the same immunity that the state does. But it's, again, you're going to have to look at that on a state-by-state basis. And what I just said about Florida is not the nationwide trend.
Now let's go to out west to South Dakota.
Hello? My name is Pat Kappenman. I'm with the South Dakota Department of Transportation. I have a question for Dr. Pivnik. Regarding the trend in the courts today on sign inspections, the frequency that the courts are looking at requiring these inspections, day and night inspections, how many times per year, and also are they relying on the information from retroreflectometers? Are they finding that this is a reliable measure? And if so, how do we obtain some information on the state-of-the-art retroreflectometer?
All right, let me answer the first part of the question first with respect to the number of inspections. Each court and each state acts a little differently than its neighboring state or its sister state. However, if you look at the trend and you look at a general approach, we find that by reviewing the cases that exist, that a semi-annual or a twice a year, let me go back, an annual check of a sign, both day and night, seems to be sufficient. The problem that you have with the use of the new retroreflectivity standards and the use of retroreflective meters is that it's a new technology that's just beginning. And one of the problems that we've seen with retroreflectometers is how it is used. When you're out there checking a sign at night, for example, and your headlights are on it, you instantly can see the entire condition of the whole sign. With the use of a retroreflectometer meter, what you're going to have to do is move the sign around, move the meter around to all portions of the sign to make sure that the entire sign is falling within what would be the accepted standard, at least the manufacturer's standard. Where you could get information, I would suggest that probably information on the use of these meters would be available from both the manufacturer of the meter and the manufacturers of the reflective material that is being tested. And that would be my best suggestion to you to get more information on it.
From the Southwest, the state of Arizona.
Hello, my name is Greg Halverson, and I'm calling from Phoenix. I've got a two-part question. Number one would be the AASHTO clear zone. We in Phoenix here have roads with irrigation channels and power poles lining the road, and we can run an AASHTO clear zone cost-to-benefit analysis saying that it's greater than 1 to provide the AASHTO clear zone. Would that hold up in court as being sufficient discretionary planning as not to provide the AASHTO clear zone? This has been a topic that's been discussed in the ITE journal from the state here in Arizona. And the part two of this question is, are we supposed to be held liable for all the new guides published by ITE, AASHTO, and the US DOT in regards to the state of the art and for the things that are out on the road right now. And in particular, the new AASHTO Roadside Development Guide has got new requirements for guardrail and curb placement. Thank you.
That's an excellent question, Greg. One for which we wish we knew the answer right away. It's going to cost a lot of money either way. Let me address the first part, and that is the clear zone requirement. The AASHTO Roadside Guide is the most authoritative document now in existence. My understanding is that it's just toward the end of the federal rulemaking process and will soon be incorporated in the Federal Aid Highway Program Manual. It gives a very clear-cut economic analysis that you need to make to determine the best use of the public funds. I can't give you an exact answer as to whether or not the courts are going to find you liable. I can tell you this. You need to make the best possible use of public safety money. And it's not good use of public safety money to move obstacles out of the clear zone if they're probably never going to be hit. Or if your economic analysis taken from the AASHTO Roadside Guide says that that's not a cost-beneficial use of those funds. I wish I could give you an authoritative single answer. The courts are going to tell us that over time. If you are working within the AASHTO Roadside Guide, in my opinion, you're doing the best that you can. Shelley is going to address the second half of your question, and that is if you have to adopt a new guide every time one is published. I'm waiting for the AASHTO Pink Book to come out because we all would love to jump in compliance with the Pink Book as soon as it's published. Shelley, explain the Pink Book to these people.
I'd love to. Let me give you a little insight on the acceptance of new standards. One of the problems that you have is the fact that there's generally lack of funding for you to go out and upgrade your entire plant. When I say plant, I mean your road system, both highway, limited access, and street system, to qualify or be in conformance with the new standards. The courts tend to recognize this situation. There have been some states that have legislated or attempted to legislate a guide to their own agencies, in as much as saying that as long as the device is still serviceable, then you do not have to remove it and replace it with a device that meets the current standards. As a general rule, what I would suggest is that as new standards become available and you become aware of them, that as long as your material or your road plant is still in good working condition, you are in a good position by maintaining what you have. However, if you have to upgrade or maintain something, then the maintenance requires you to conform with an acceptable standard, which may be the current standard. If you do any new construction, again, you're going to have to conform to that standard. You're really in a catch-22 position. I would make every attempt to follow the standards as the standards become available. The more states that adopt the standard, the ones that don't follow that standard are now being put in a position where they're going to be in court to defend their action and explain why they didn't. Dan, I think you had something to add to that.
I'd like to make one quick comment. I'm familiar with the fact that over the last 3 years, one half of the states have tried to have adopted legislation that creates a design immunity. That is, if something was placed in the field, designed to the standard of its day, it should be immune from suit. In Arizona, that's a particularly pertinent question because I know some of that legislation has been involved in your state. Only about one half of the legislation offered was actually adopted. So you put your finger on a very prevalent current question.
I'd like to just point out one thing on design immunity. There have been several states that have legislated design immunity only to have the courts come down and say that design immunity is not perpetual when there are change conditions, and this change condition has resulted in an unsafe situation and where the government agency is familiar with that. So even legislation has its own problems.
Okay, quickly now from one of our downlink stations in Alabama.
This is Joe Roofer in Mobile. I have a question. State Senator Charles Bishop, in voicing his concern, brought to my attention a recent opinion issued by the Alabama Attorney General that in effect says resurfacing of a road is maintenance as opposed to construction, and therefore the services of a registered professional or licensed engineer are not required for the preparation of plans and specifications nor during construction. The question is, what effect will this have on the tort liability of those who choose to follow that route in not using a licensed or registered engineer for this work?
That's a tough question, Joe. I wish I knew that answer right away. Any organization is allowed to maintain its facilities. In maintaining them, you want to show that you have a standard of care. And that's one reason that an engineering license is required for new design, is to ensure a trained designer and a standard of care. If your organization has a standard of care for maintenance, including overlay, that's well within the currently accepted standards, in my opinion, you should be all right. That's the best answer I believe I can give you right now, Joe. Unfortunately, in a lot of cases, the bottom line is the court will interpret that for us.
Okay, thank you very much. I think our time is limited now. Let me just ask this, that if you didn't get your questions answered, drop us a line and we'll try to get a written answer back to you on your questions concerning tort liability. On behalf of Auburn University and the Alabama Technology Transfer Program, we're very pleased to have participated in this element of our national telecast. Now we'll throw it back to you, Sarge, and good luck to you.
Thank you very much, Fred, Dr. Turner, and Dr. Pivnik. Next, the director of the New Hampshire T-Squared Center, John Anderson, will be explaining a system they've developed at the University of New Hampshire for roadway surface management. This is on videotape.
Hi, I'm John Anderson. I'm director of the Technology Transfer Center at the University of New Hampshire. And I'm here to talk to you about a program that we developed to help the local government officials in New Hampshire implement a road surface management system, which we refer to as RSMS, in their towns. RSMS is a computer-based system that handles flexible pavements and also unsurfaced roads. The unsurfaced roads portion of the program was developed under the guidelines of a report that was put out by the Cold Regions Research Engineering Laboratory in Hanover, New Hampshire. The flexible pavement portion of the program was developed by coordinating the local officials, the planning commissions, the New Hampshire Department of Transportation, Federal Highway Administration, and university personnel in order to come up with a program that was going to be practical, that's going to be efficient, that was going to be effective, that could be a low-cost alternative to other types of pavement management programs. RSMS first starts by doing an inventory of a road system. That includes putting the name of the road, the widths of the road, the surface type, maybe there's an identification number that goes with the road, things like that. They go into a database. From that database, sitting in an office, somebody can go through and look at a map and determine exactly which roads on a particular day that they would like to go out and do a condition assessment on. Possibly they might sequence out 30 roads. We found that most of the towns can do up to 60 miles of road in one day. After sequencing the roads, the individual who's going to be going out and collecting the field data would go out to a vehicle and take a laptop computer and what we call a fifth wheel, which attaches to the back of the vehicle, plugs into the computer, and automatically inputs the mileage on a particular road. Also attached to that is a digitizing tablet. We've done that in order to avoid having to type in on a computer all of the information from the condition assessment. The exciting part about the program, about using this laptop computer and using the digitizing tablet, is that as soon as you get back from the field, you're all ready to do your analysis and all ready to look at your reports. The cost of the hardware, the laptop computer, the digitizing tablet, the fifth wheel, is approximately $2,500. The program itself can be acquired from the New Hampshire Technology Transfer Center with a full manual and software for approximately $16. Soon we should have that program running through the McTran Center down in Florida. For more information on this program, contact your Technology Transfer Center in your state. Thank you very much.
We thank Dr. Anderson at the University of New Hampshire for sharing that with us. He's involved in the T-Squared program. Right now, Dr. John Mason is an associate professor of civil engineering at the Pennsylvania State University, Pennsylvania Transportation Institute. And he is going to be available to answer your questions after he makes this presentation. It'll be just the same as we did during the Alabama segment, except that Dr. Mason is here in Harrisburg with me.
Hello, I'm John Mason. I'm a faculty member in the Department of Civil Engineering here at Penn State University. With me is Walt Kiloreski, who's also a member of the Civil Engineering Department, and both of us also serve as program directors at the Pennsylvania Transportation Institute. Recently, Walt and I have been involved in a very interesting and successful project called Local Road and Street Safety Improvement Program, which we'd like to describe for you today. Our presentation will explain how we developed a 1.5-day short course and how we conducted a series of on-site visits to several local municipalities in Pennsylvania. The two-part project was implemented to help local agencies improve the safety of their roads and streets.
This project was sponsored by the Pennsylvania Department of Transportation and funded by the Federal 402 Highway Safety Program. Additional support and assistance were provided by the Center for Highway Safety and the Office of Research and Special Studies at PennDOT. The main focus of this project was to encourage the establishment of a viable safety process at the local municipal level. We were not interested in identifying or correcting site-specific safety problems. The project objectives were to develop and present a 1.5-day short course that would emphasize the benefits of a local road and street safety improvement program, conduct on-site visits to assist local agencies in developing, implementing, and maintaining a practical safety improvement program.
The project began in July of 1988. Over 150 local municipalities with high accident frequencies had been identified by PennDOT. Representatives from PennDOT, the Pennsylvania RTAP program, and the Pennsylvania Transportation Institute conducted a joint meeting to screen the 150 agencies using the following criteria. Their population would be between 15 and 25,000. There would be indications of past interest in programs of this nature. The local agency would be located in a growing suburban area. And finally, the selected municipalities would represent a good cross-section of local government throughout the state. 30 local governments were selected from the original 150. The candidate municipalities were sent a letter of invitation to attend the short course. PennDOT provided all accommodations and all materials. Approximately 30 days before the course, 25 different agencies had accepted the invitation. In developing the short course, we assembled the majority of the information from 4 Federal Highway Administration publications. One of them, the Local Highway Safety Studies, published in 1986, the Local Highway Safety Improvement Program, a user's guide, also published in '86, and Functional Requirements of Highway Safety Features, published in '84. Finally, the Guide to Safety Features for Local Roads and Streets. The course notes were modified to represent PennDOT design criteria and standards. The combined information, accompanied by a set of instructional slides, was summarized in 2 notebooks. One is referred to as the participant's notebook, and the other, the instructor's notebook. The text of both notebooks is identical. However, the text of specific discussion issues is highlighted in the instructor's notebook, and there is a slide key along the side of the text that equates the text to a numbered slide. In February of 1989, we presented the short course to 30 representatives from local agencies. The course was divided into 6 sections. Section 1 was about 1 hour in length. It introduced the topic of road and street safety improvement programs. Section 2 was considered a primary topic of discussion. For 3 hours, we covered specific examples of roadway safety improvements. The elements of an effective improvement program were outlined in Section 3. This section was also considered a topic of primary importance, as we devoted 2.5 hours to the benefits of establishing an effective safety improvement program within a local municipality. Section 4 identified various issues that should be considered when developing alternative countermeasures so that safety improvements that are feasible and practical would be implemented. An overview of economic analysis procedures were presented in Section 5. Evaluating the cost-effectiveness of safety improvement projects was a major emphasis of this section. The last section, Tort Liability and Risk Management, was of particular interest to all participants. The purpose was to heighten the awareness of tort liability issues. Additionally, the process of establishing a risk management program as a means of reducing roadway tort liability was explained. We devoted approximately 1 hour to each of the last 3 sections of the short course. The tort liability section raised the most concerns and stimulated significant discussion among the participants. This reaction is common among representatives of public agencies whenever the issue of tort liability is presented. At the end of the short course, 20 municipalities indicated an interest in an on-site visit from the PTI staff. The on-site visit created a multi-dimensional opportunity. The agencies could increase the number of people involved in the training opportunity. PTI staff also were available to answer specific questions on the storage and the use of accident data and determine how this information was being maintained within a particular local government. The on-site visit also gave PTI staff the opportunity to provide general guidance in establishing procedures for identifying appropriate countermeasures at high accident locations. PTI did not conduct any isolated or individual corrective studies. I'd like Walt now to highlight the key features of the on-site visits and summarize some of our findings.
Thanks, John. As John mentioned earlier, the focus of the site visit was for PTI to provide guidance to the municipalities and to offer training to additional personnel. We developed 2 broad agendas for each site visit. A 1-day agenda contained 2 sessions. The first session typically lasted 3 to 4 hours and consisted of a review of the record-keeping systems for the municipality, identification of changes or improvements in their record-keeping procedures, and a demonstration of available software. The other portion of the site visit was reserved for discussions on risk management to reduce roadway tort liability. The 2-day site visit expanded the 1-day agenda to include presentations on key elements from the participants' notebook. Information from Chapter 2, Roadway Safety Improvements, and Chapter 3, the development of a roadway safety improvement program, were usually requested. One of the more interesting features of the on-site visit was a software demonstration. Most of the municipalities already use computers in some areas of local government. A few have begun to use the microcomputer as a roadway management and record-keeping tool. However, our microcomputer demonstration included an overview of the following software. First, a database manager, which was DBase 3, and a spreadsheet software program, Lotus 123. These software packages are very common and are available at a reasonable cost. We also presented specific software examples using HiSAM and HiSafe developed by the Federal Highway Administration. The HiSAM program is used to identify high accident locations, analyze accident characteristics, and produce standard accident analysis reports. The information generated by HiSAM program can be used as a general roadway database. HiSafe is designed to evaluate the effectiveness of alternative accident countermeasures. Both of these programs are available from McTrans at a cost of approximately $50. In addition to the microcomputer demonstration, selected reference materials were made available for municipal representatives to review during the site visit. The publications included documents from PennDOT, Federal Highway Administration, ITE, TRB, AASHTO, and other readily available materials. During each site visit, PTI personnel met with a pre-selected group of individuals which generally included representatives from administrative units, police departments, Department of Public Works, and the Highway Department. The structure of the meeting was flexible and informal. Usually 8 to 10 individuals attended the meetings. A detailed questionnaire was used to help PTI personnel identify and summarize each agency's current policies and procedures. The questionnaire also served as a vehicle to engage the participants in discussion and group interaction. The meetings were usually attended by township managers, elected officials, highway crew, and associated office personnel. We visited 9 local agencies during the spring and summer months of 1989. The characteristics of these municipalities can be summarized as follows. Average population was 25,000 residents. Average geographic size was 19 square miles. Total miles of municipal roadway averaged 80 miles with an annual operating budget between $2 to $4 million. Agencies reported between 1 and 3 accidents per day. Most of these accidents occurred at intersections. Fatal accidents were typically found in rural areas and could be classified as run-off-the-road accidents. When we looked at the data collection and maintenance of records concerning traffic accidents and roadway maintenance, we found that separate departments in municipalities usually kept different portions of the records. The general findings on data collection and maintenance were: at each municipality, the police department was responsible for maintaining accident data. Some police departments have a traffic safety group who conduct detailed accident investigations. Most municipalities conduct traffic counts on an as-needed basis. ADT information was typically stored as hard copy files. Road and street information was processed on an informal basis at most municipalities. Several local agencies retain work orders and purchase records. Others have a regular inspection program. If specific records were kept, sign inventories and roadway marking locations were often given top priority. Traffic engineering studies were generally conducted on a limited or very preliminary basis. Only one municipality reported occasional use of collision diagrams in accident analysis. All municipalities reported that they do conduct spot speed studies. However, ball bank studies, site distance investigations, and traffic conflict surveys were used with less frequency. The results from the studies were usually given to administrative personnel for review and consideration. The number of traffic-related lawsuits ranged from 1 to 5 per year. Accidents resulting in serious injuries or fatalities were the most frequently discussed liability issue among municipalities. In summary, we found that the majority of municipalities have at least one traffic-related lawsuit pending litigation. Several municipalities have a trained accident reconstructionist on their police staff to investigate accidents that have a high probability for a lawsuit. Now I'd like to give John an opportunity to present the overall evaluation of the project.
Thanks, Walt. I want to close our presentation by summarizing the short course evaluations and the major findings of the project. During the short course, the participants were given several evaluation forms. They were asked to evaluate the short course on a wide range of issues. For example, they were asked to rate the perceived usefulness of the 6 sections of the course and also comment on whether or not the course objectives were met. The participants gave a high rating to the course content, its materials, and the overall presentation. Also, a majority of the representatives indicated that the course objectives were certainly met. If we summarize the significant results of the short course and the site visits, we find that the most interesting rating was given to the risk management portion of the project. Safety improvement examples and feasible countermeasures were given a very useful rating. The participants recommended that the program could be divided into 2 sections, one geared to urban areas and another to the rural developing areas. During the on-site visit, the participants asked a very broad range of technical and legal questions. PTI provided a flexible agenda. It was this element that made the on-site visits meaningful to the participants. almost every municipality expressed a need for assistance with microcomputer database development. It seems that additional work must be done to help local governments in actual software development using practical and very relevant examples. As a result of this pilot program, PennDOT is planning to add a liaison safety engineer to its RTAP staff. This person's responsibility will be to generally fulfill the objectives established in this effort. It is also envisioned that a long-range evaluation plan will be developed to measure the overall effectiveness of a continuing program. The staff at PTI would like to thank PennDOT and RTAP for their assistance, but I think we owe a special thanks to the people in the local municipalities, the township supervisors, elected officials, the highway crew, and office personnel. They all supported our pilot project. The program's continued success will depend on their renewed efforts to improve the safety of our local roads and streets.
We're back live now in Harrisburg. Dr. John Mason with Penn State University is with me here. We have not yet received any questions from you. That either means that you're falling asleep or that Dr. Mason's tape was so thorough that you have no questions to ask. I have a couple of questions for you, John. One is, how replicable is this program? Assuming someone in Kansas or North Dakota or somewhere wanted to do the same kind of thing, how could they replicate it from what you've done?
Okay. Well, one of the primary reasons for PennDOT and RTAP asking us to put together this tape, it was in case there was some interest in trying to utilize the course materials. They are readily available, and the tape itself, we hope, is self-explanatory, and so I think it can be replicated by the fact that we used FHWA information. The notes are a little more specific to PennDOT, Pennsylvania situations, but nonetheless, I think any state taking the information as a core could certainly improve upon it for their own.
Now, I have to confess, when I was watching the tape, and I think I mentioned this to you while the tape was rolling, it strikes me that this is almost a redundant kind of program, that you are going out and telling everyone what they already know. Now, you told me that was not the case. Could you just sort of underline that?
That's true. I think many state municipalities, states and municipalities within those states, are inundated by technical information time after time. And we just assume that they have adequate staff and adequate resources to accomplish these objectives, but unfortunately they are being asked to do more with less. And I made a few notes, and one of the things that I wanted to say was that we found that at local municipalities, it's not necessarily true that because they're receiving less funds that they're doing less work. They're trying to be a little more creative about how to do things. And that's why the microcomputer activity was so important to them. They wanted to know, how can we use software in order to do several of these things simultaneously? And that was the fundamental shortcoming, that they say we have the equipment and we have some funds for that activity, but the software is not very realistic.
Yeah.
The other aspect was these alternative countermeasures. We heard some questions earlier about, in Arizona I think it was, that we have a clear zone concept, and how do we accommodate that from a cost-effective point of view? While sometimes the cost-effectiveness analyses are not very easy to do. And so we wanted to demonstrate that there are some relatively simplified approaches to the problem, as long as there's a logical step-by-step process, and if there is some tort litigation, you can explain it to the courts, and it sounds like a reasonable way of spending public money in the interest of their safety. We felt that that would be a good cost-effective approach. But FHWA does have those booklets available, and we simply combined them into a usable format.
Did you have any difference, I guess, in receptivity or an attitude toward the question of local traffic safety as you went around the state of Pennsylvania?
I would say the municipalities, although they were supposed to be small in size, for those of you that aren't familiar with Pennsylvania's subdivision system, we do have numerous townships throughout our state of Pennsylvania, and some of those townships now feel the influence of urbanization that they never felt before. Those municipalities were welcomed us almost with open arms because they felt the litigation pressure, the demands of the people that live there, that they expect a certain standard of care that maybe the people before them didn't see the need. And then when we went out to the suburban or rural area, some of them were surprised.
Which there's a lot of in Pennsylvania.
Which there are a lot of, right. Some were surprised that they had certain responsibilities that could cause some litigation problems. So from that aspect, I would say it depends a little bit on the nature of the land use and the nature of the local government. So it's not to say that the rural people weren't interested in safety. It's just that they may not have seen the litigation problems as some of the urbanizing areas.
And the implications.
And
I mean,
the
they can
implications,
have their
true.
entire budget wiped out with one good lawsuit, right?
Or their insurance policies go up, their premiums go up significantly.
Okay, so correct me if I'm wrong. It strikes me then that what you're doing in this, I guess, pilot program is what you call it in Pennsylvania. I mean, it's really an active outreach kind of thing. This is not where people came knocking at your door and said, oh, we need it, but now there's some folks who are saying, hey, we do need it.
Right. As a matter of fact, if you recall from the tape, it said that 20 of the 30 wanted us to come. And what we decided to do for the first year activities, and for the pilot element, we do 9 or 10 the first year and then evaluate it. Those evaluations were such that sent them back to PennDOT with exactly what our findings were. And their attitude would be one of, we need to continue this, so that's where the safety liaison engineer is coming from. That as part of the RTAP program, that person's activity would actually be to go out there and meet with the municipalities on a regular basis.
Okay. Do you have anything else you want to add to summarize? Because we're going to move on to the next segment pretty soon.
Okay. I don't think so. The only point that I'd like to leave with everyone is that the materials are developed in a slide tray format, very conducive to traditional presentations, and many of the people out there I know have put on short courses like this before. So it takes a minor effort to simply update it for the particular state you're working in. Other than that, I would say the tape is available. You can contact the Pennsylvania Department of Transportation, their RTAP group, and their goals are to make a few copies of the tape and send it out to anyone that wants to use it in their state or at their local level.
Okay.
Well, thank you very much.
Wait, we have a call coming, John. If you could perhaps recite a favorite poem or something like that until we get to it. Any other general notes? I'm sorry Dr. Kelereski couldn't join us.
Yeah, well, Walt has to. We made a deal that one of us would cover the class, and it was his turn to cover the class, and I'd get to smile in front of the TV today.
Okay. We're going to have a call coming in from somewhere fairly soon. From somewhere in Pennsylvania, as a matter of fact.
Okay. Maybe it's one of the municipalities we visited.
That's
They'll
right.
tell me if I said something right or wrong.
With a complaint. Have we got that yet? Okay, we're still waiting for that. Do you drive much in your work?
Just a little bit, all around the state, and some of the other people, our friends that were seen on the air today, I sometimes fly and put on these courses in other parts of the country, including Texas and Alabama.
Oh, is that right? Do you have
I
much
better
time
name them all now, so right. Almost every state we've been into, that's right.
Wow. Okay, all right, we lost that call, John. All right, Dr. John Mason is with Pennsylvania State University, and he has been very nice to join us today. Right now, we're going to be taking a short break. Have a good time. Please return in about 15 minutes. 20.